Drunk driving penalties in New York State are tougher now than ever before, but the vast majority of drivers charged with DWI here in Erie County never face those punishments. News 4 Investigates is digging into the numbers. Here's News 4's Lou Raguse.
Here is a shocking statistic for you. Over 2,600 people are arrested in Erie County each year for misdemeanor DWI, but just 17% of them are convicted of that charge. That's down from more than 30% just a few years ago, and we wanted to find out why. When John Jankowiak was first arrested on drunk driving charges 1 year ago, police say he hit a utility pole, ran from them, and refused to take a breath test.
He urinates on the floor. When confronted about urinating on the floor, he denies urinating on the floor and keeps on urinating on the floor. That's how drunk this guy was.
But the judge in the case did not convict him of misdemeanor DWI, the crime he was charged with, instead dropping to the lesser violation called driving impaired. At the time, Erie County District Attorney Frank Sedita was furious.
So do you think he learned his lesson?
I don't know what lesson he was being taught.
And now, 7 months later, Sedita believes judges in Western New York are more lenient than the rest of the state when it comes to misdemeanor DWI. The numbers back him up. In 2012, 83% of drivers in Erie County charged with misdemeanor DWI had their charge reduced or dismissed. That ranks Erie County near the bottom of the state for convicting drunk drivers on their original charge, 52nd out of 62 counties. Several of Western New York's other counties also rank low.
I'm wondering if that's saying something about Western New York.
Defense attorneys say the DA's own plea policy leads to a lot of the reductions.
Usually it's common practice for there to be an offer to a driving while impaired instead of the driving while intoxicated.
If it's a first-time offense, there's no accident, and the driver's blood alcohol content is not above 0.13, Erie County prosecutors will usually allow the driver to plead guilty to driving impaired instead of driving while intoxicated. But Sedita says there are many more serious cases where prosecutors take the case to trial, and it's the judge who decides to show mercy.
I would say the judges want to give a first-time offender a break.
To understand why prosecutors and anti-drunk driving advocates see that as a problem, you have to understand the difference in punishment. Misdemeanor DWI is a crime for which state lawmakers are constantly pushing for more consequences, while driving while impaired isn't a crime. It's a traffic violation that carries with it a fine and a suspended license.
Impaired is the same level of crime as a speeding ticket or running a stop sign or something like that.
It's a bad thing because I think that they need to come down hard on them the first time so that they don't reoffend.
Elizabeth Obad, the president of Erie County Mothers Against Drunk Driving, fought hard to require ignition interlock devices to be installed when people are convicted of DWI. It requires the offender to blow into a breathalyzer before starting his car. But if a driver's charge is dropped down to driving impaired, it's not required.
There has to be a penalty that fits the crime.
And if the person convicted of driving impaired gets picked up again, they're technically not a repeat offender, and they can't be charged with a felony. Through Freedom of Information requests, News 4 obtained conviction rates for each city, town, and village court in Erie County. The town of Amherst saw the most misdemeanor DWI cases in 2012 at 443. Judges there convicted 16.9% on the original charge. The city of Buffalo convicted 15.6% of its 313 misdemeanor DWI cases. The towns of Boston, Grand Island, Lancaster, Newstead, and the villages of Kenmore and Lancaster all convicted less than 10% of DWI defendants on their original charge. John Sullivan of Erie County Stop DWI compiles drunk driving statistics. He believes some judges are reluctant to convict because of the steep penalties included. And Sedita agrees.
There is some sympathy for a drunken driver, a one-time offender, a first-time offender, never had any trouble before.
But what we're seeing in reality is that the judges, or some judges, see that the sanctions are so punitive, and it's also going to require them, the judge, to continually monitor the defendant, that it's a whole heck of a lot easier just to do the impaired. So it's kind of having the opposite of the intended effect.
An ironic effect of the fight for stiffer drunk driving penalties, but the numbers are something advocates want to see reversed. Sedita wanted to point out a positive stat. 96% of DWI cases end up with a conviction of some sort. So even though the vast majority of them get dropped down to a lower charge, very few people are walking away with nothing. It's just not the same punishment the original charges called for, which advocates have worked hard on making tougher. Lou Raguse, News 4.